got so motherfucking design on right now. Bring it down, bring it down, bring it down. I got 3 old guys on the block.
Will you state your name for the record, please?
Michael Williams, Ajax.
And Mr. Zajac, do you live on Furnace Hollow Road?
I do.
Okay. And did you have an occasion to contact the police back on August the 1st of 2024?
I did.
And can you tell us what happened at your home and what you saw that evening?
Yes, on that evening, I had just returned from a trip from Chicago. I'd only been home for probably less than 2 hours. At that time, we're getting ready for bed, getting the kids ready for bed, and I noticed floodlights coming on outside. The floodlights are motion activated, so I thought it was suspicious. And as I walked around the house, I saw more floodlights going off. So I went out on the front porch, at which point I encountered Mr. McElhaney and asked him to leave. I asked him, he said he was there to see John. And I said, there's no John here and you need to go. And at that point, I realized I was sitting on a brightly lit front porch with him in the shadows. So I retreated back into my home and grabbed my pistol and made sure he had left the premises.
All right. Did you determine at a later point that Mr. McElhaney had gone into any of your buildings or home?
Yes, I did. Upon running into that, I did look at the video. I did see him walking around the property with a flashlight and a dog. On every single one of my, I have multiple video cameras on the property. Every single camera saw him, got a very good look at him at the doorbell, peeking into my windows, where my daughter was sleeping on the couch, and also realized that he had entered into my attached garage and also my barn on the property.
Okay, so you had surveillance footage, is that correct?
Yes, he was also using his flashlight to look into the 2 campers on the property and trying the doors to get in those as well.
Okay. And did you provide that footage to the detective, I guess, in this case?
Yes, I did.
Okay. And did your video show that all of that, what you had testified to about peeking in the windows and going into your attached garage and the camper, did that all occur that same day?
Yes, just for clarification, he did not enter the camper, but he did enter the barn, and yes, that all occurred at roughly the same time period.
Okay. Thank you for clarifying. Was anything stolen from your property?
Nothing tangible, but my family's security was stolen that night.
Okay. Well, tell the court how this crime affected you and your family.
Yeah, as a result of this crime, my family has had trouble sleeping. They've had trouble, being secure in the home. Every night, one of us checks multiple times every single door to make sure it's locked. We've had to invest thousands of dollars into a security system and pay a monthly fee. And my family is in fear when I leave the house, which is weekly for work, that I travel for work. So it's had a very significant and profound impact on my family. Like I said, their sense of security has been stolen and no amount of money can give that back.
Okay. Are your children minor children?
Yes, at the time of the incident, I had a 7-year-old and a 12-year-old, and the 12-year-old was asleep on the couch.
Okay. Is there anything else you want to tell the court in regards to this incident?
First of all, I would like to thank the Dixon County Sheriff's Department for their promptness and professionalism throughout the course of the incident, and would also just like to state that again, there's got to be people have to be accountable for their actions. This action has a profound and deep impact on my family, and in this case, considering the history, we'd like to request the maximum penalty.
Okay. Thank you, Mr. Zajac. I appreciate it. If you'll just answer any questions of the defense.
Yes, ma'am.
Talbot? You reviewed the video footage from your home security cameras,
Yes.
and you saw the defendant at your property?
Yes.
Now, based on the time of that footage, was that prior to or after the interaction that you had with the defendant?
I believe it was prior to the interaction. Based on the footage, I had asked him, when I asked him to leave, it appeared that he retreated back towards some overgrowth by my barn, which I have since cut down. As a result of this incident, did significant property maintenance to make sure that there was no hiding places. It appeared that he was hidden, and as I walked out and I yelled, if you're still here, you better not be. And at that point, he appeared to retreat off the property.
Okay, so you've got your video footage that shows the defendant at your property
Yes,
at a certain time.
Yes.
And then later that evening, is it fair to say, that's when you noticed somebody out there and you spoke with the defendant, told them
Yep.
to leave?
Yes.
Is that a fair timeline? Is that a fair timeline?
I'm not, you didn't say any times on there, but it
Sure.
sounds right.
We'll say
The order of
sequence
events, yes.
Sure. When you interacted with the defendant, he had told you that he was looking for a John.
Yes.
What was the defendant's demeanor like at that time? How would you describe his behavior?
I would say he seemed sleepy, I guess for lack of a better word, and aloof.
Did he seem confused?
No, I wouldn't say it in those words.
You said sleepy. Was he unsteady on his feet, or did he have a certain expression? What made you think sleepy?
It was hard to tell just by the tone of his voice. He was kind of in the shadows when I encountered him.
Okay. All right. Thank you, sir.
Thank you.
Redirect. Thank you, Mr. Sajak. You may step down and have a
Thank you.
seat in the courtroom. Statement, call your next witness.
Good morning.
Good
Will you
morning.
state your name, please, for the record?
My name is Mildred Thaxton.
And Ms. Thaxton, you live on Eno Road, is that correct?
Yes, ma'am, I've lived there 65 years.
All right. That's a long time. Did you have a reason to contact the police back on August the 1st of 2024?
Yes, ma'am, I did.
Okay.
My
Can-
son called me and told me to lock both of my doors, turn my porch lights on, because he saw a guy in his yard. But the time my son went in the house to get his gun to, go out there and talk to the guy, he was already in the woods. And my son told me he's headed my way, so he came in the woods to come to my house.
So does your son live like on an adjoining property?
Yes.
From you? How far away would you say he is from you?
I would say probably 2 blocks, maybe.
Okay. All right. So a little bit away, but not too far.
No,
Okay. And so he reached out to you to make sure that you were safe.
right.
Was there anybody else in the home with you?
No, ma'am.
Okay. Did you do what he said? Make sure
I
you
did.
locked your doors and,
I did.
okay. Did at some point in time, did you encounter Mr. McElhaney?
The only first time that I encountered him was when he was on my front porch.
All right.
He had laid the gun down there on the chair, and he wasn't knocking like he would, want me to come to the door. He was pounding on my door,
All right.
and I was so scared. And then this was at 11 o'clock at night, and I heard my pump come on. And I thought, they're not feeding the horses out there this time of night.
Tell me what that means by the pump. Is it like a
I have a well.
well? Okay.
I have a well.
And does it make a certain type of noise or something when it
Yeah,
comes
it
on?
comes on because it's on my back porch. The pump is,
I see.
and so it comes on when the water comes on. So I went to the bathroom and looked out the window, and he was taking his clothes off. He'd already taken his shirt off, and he had the hose, and he was spraying his body down. So I went back and I called my son again. I said, please tell the cops to come quickly because he's here. And so he sat down on a cooler that I had on the patio, and then that's when they came in and got him.
Okay. So if I understand the order of events, he came onto your porch first, is that
Yes,
correct?
the front porch.
Were you able to see him on your
I
porch?
could see him through the crack of my window.
Okay. And did he appear, or did you think he was trying to come into the house, I guess is the
I knew
question.
he was bound and determined to come in my house.
And tell me why, like what made you
Because the
feel
way
that?
he was knocking on it.
Okay.
Normally, a person, if they come to your house, they would just knock, with their hand, but this was pounding.
Did he jiggle the doorknob?
Yes.
Okay. So in regards to the gun, were you able to identify the gun?
Yes, I did.
And how did you know who it belonged to?
I knew it was my son's because my husband gave it to him.
Okay. And when did you see the gun laying on your porch?
As soon as I heard the knock on the door, I could see out the crack of my window, and it was laying across the chair there by the door.
Okay. And that was during the time that Mr. McElhoney was up there?
Right.
Okay. And at some point in time, did you get the gun off of the front porch and bring
I
it
did.
inside?
I did.
When was that?
After he had left off the porch. I didn't know where he went, but my son came down there, and we took the gun in the house.
Okay. Can you tell the court how this experience has made you feel? How it's
Well,
affected you?
I have had many, many nights of sleepless nights, plus I had to go to the ER, and my heart doctor had to put me on some depression medicine because I couldn't sleep. And I've never had an experience like that. Like I say, I've lived there 65 years, and we have never had anything like this to happen.
Right.
And I was talking to my neighbor, the one that just you interviewed, and told him, please don't move out of the area because we don't never have anything like this going on in this area. Please don't move back to where he came from,
Sure.
because they were really nice people.
Right. Is there anything else that you wish to tell the court in regards to this experience or just in general?
Well, just like I say, I've never been through anything like this, and it's been devastating to me. I try to stay busy to keep my mind off of it, but it's hard. And then, like I say, I'm not getting much sleep at night. This has been going on for quite some time now.
Okay. Thank you, Ms. Thaxton. I appreciate it. If you'll answer any questions of the defense, please.
Mr. Talbot, you have questions?
Ms. Thaxton, this happened in August 2024, right?
Mm-hmm.
So over a year ago?
Over a year ago.
Okay. Has your sleep improved at all?
It has some, taken the medicine that the doctor gave me, but I'm still having nightmares.
And you said that you went to the ER after this incident. How quickly did you go to the ER after the night?
I was trying to make my mind up if I really wanted to go or if I didn't want to go. I didn't call any of my family. I just got in my car and I drove myself over there, which I shouldn't have done because I was in such a state of mind, but I did.
Was that the next day or how soon after?
That was that morning at 1 o'clock.
So in the middle of the night, you went to the ER after this?
Right.
Okay. Were you diagnosed with any kind of new condition as a result of this?
They just said it was anxiety.
Okay. You stated that the defendant pounded on the door. Okay. Was this the same kind of knocking? Well, what did you take the pounding to indicate?
I think maybe he thought that if he pounded hard enough that the door would come open because I live in an older home. And I felt like that's what he thought he was going to do. And at that time, I went and got my gun. I'd hate to know that I had to hurt anybody. I'm not that kind of person. But if somebody's going to come in and try to kill me, I'm going to take revenge.
So the pounding on the door, you would agree that people knock on doors in order to get the attention of the occupant inside the house?
Yes.
So couldn't this have been knocking on the door to get the attention of you inside the house?
Well, I mean, it could have been, but when he started pounding on it, that's not a regular knock. That's determined they're going to try to get in.
Okay. But to be sure, The defendant never entered your home, did he?
No,
Okay. And he took none of your property, did he?
no, not that I know of.
Okay. All right, thank
I'm
you.
sure there's some in the woods back there somewhere because as far as I know, there was about 11 homes affected that day.
Thank you.
Redirect. Thank you, Ms. Thaxton. You may have a seat. An argument.
Your Honor, just to recap what, and you may have it already in front of you, what Mr. McElhoney pled to in the agreement when he pled open on these charges is he pled to, on 2024 CR 134, he pled to count 1, aggravated burglary, which is...
Your Honor, I have to interrupt. I'm objecting. He didn't plead open. We have an agreement about the cap on sentencing. It's 10 years in the aggregate.
Gap of 10 years aggregate sentence be concurrent with the only other considerations.
That's correct, Judge. That's what I was...
I have it in front of me.
Okay,
I want
thank you,
to
Judge.
repeat it.
That's what I was just trying to say. I was going to say the cap of 10 years before Mr. Talbot jumped up, so that's what we're looking at, Judge, as well as the fact that he pled to the burglary of a vehicle and the attempted aggravated burglary and agreed that he would be a persistent offender. Judge, I think what the court needs to face is the fact that it has an extremely long criminal history. He has been involved in committing crimes since at least the age of 20, according to the precedence report, all the way up until these latest crimes at the age of 40. The state did file notice of enhancement factors in which the state intends to rely upon under 4035-114, and that was that the defendant has a previous history of criminal convictions or criminal behavior in addition to those necessary to establish the appropriate range. Obviously, Judge, based on the fact that he has numerous felony convictions, my count was 9. Mr. McElhoney said it was 7. I would just ask the court to look at the notice of enhancement that the state filed in regards to looking at the prior criminal convictions. The other enhancement factors that the state placed on their, Judge, was that the victim of the offense was particularly vulnerable because of age or physical or mental disability. You heard today that Ms. Thaxton testified on there, and obviously Ms. Thaxton appears to be extremely sound mind and very capable. However, she is of older age and was alone in that home that night when Mr. McElhoney tried to break in. So I would ask the court give some weight to that. Number 13, at the time the felony was committed, one of the following classifications was applicable to the defendant, and he was released on probation. Obviously, there's no argument there. He was on state probation for a burglary other than a habitation in which he'd received a 3-year sentence out of Murray County. He was on probation for, it looks like, approximately 7 months before these offenses were committed here in Dixon County. And then the last one, Judge, was number 29. The offense involved the theft of a firearm from a motor vehicle. While the theft itself was dismissed, Judge, he was in fact was found guilty of burglary of a motor vehicle in which the only item removed was a firearm. And there was, of course, testimony in regards to, from Ms. Thaxton, in regards to the fact that she observed the gun there on the chair with Mr. McElhoney there next to it when he was attempting to get into her home. The points that I wanted to bring up, Judge, is this. Mr. McElhoney has had numerous opportunities throughout his life to seek treatment, to get help. I have no doubt that he has a drug problem, but it falls back on Mr. McElhoney to make that choice. He testified on the stand that his children were taken due to drug usage, but he didn't seek treatment at that point. That his loved ones, his aunt testified that she tried to get him to go to treatment, And he wouldn't go to Synergy at that point in time either. And then while he was on probation for Murray County, where the probation officers who are willing to assist and get someone into treatment, he didn't request treatment then either, and that was in January of 2024, or up till time of these offenses. And so now we're here before the court, and Mr. McElhaney is facing a lengthy prison sentence, and now he has discovered that he wants treatment. And I think at this point in time, Judge, my argument would be whether or not he deserves to have yet another opportunity, yet another chance. And the reason I say that, Judge, is that what he's been convicted of is serious. He may not have stolen anything that day material-wise, but he stole people's peace of mind, and he stole their security within their own home. And you've heard from two separate victims that told you that. You can't get that back after something like that has happened. Ms. Thaxton stated that she ended up having to go to the emergency room due to what happened to her. And at this point in time, Judge, I am asking that Mr. McElhaney take whatever opportunities he has in prison for treatment, and that's how he goes about and receives his treatment. And I'm asking the court to sentence Mr. McElhaney to serve the full 10 years, up to 10 years in prison. Thank you, Your Honor.
Mr. Talbot?
Thank you, Your Honor. The defense also filed a notice of mitigating factors and some supporting documents. And we would ask the court to consider the following mitigating factors. That the defendant's criminal conduct neither caused nor threatened any serious bodily injury. From the evidence that was presented today, it's clear that the defendant at no point threatened anyone with any kind of harm, made no verbal threats, and no one was in fact harmed, incurring serious bodily injury. And in fact, the testimony from Mr. Zajac was that when he directed the defendant to leave his property, the defendant did so. Further, we would ask the court to consider that the defendant was motivated by the factor that the defendant was motivated by a desire to provide necessities for his family or for himself. In this case, the defendant did testify that he was seeking water and gasoline for the vehicle that he was using, and that was the purpose of him looking around these properties of the victims. And again, he took nothing. We also ask that the court consider Factor 11, that the defendant, although guilty of the crimes, committed these offenses under such unusual circumstances that it is unlikely that a sustained intent to violate the law motivated the conduct. The defendant testified that he was under the influence, which on its own is not a factor that the court should consider, but it is part of the circumstances in which he, under the influence, found himself more or less stranded due to his vehicle that he was using running out of gas, and that he was then looking, based on his testimony, for something to refuel his vehicle and water on an August night. I would also ask the court to consider that Mr. McElhaney's drug use has cost him a lot and played a role in a lot of the criminal conduct that forms his history. He admits that he does have a drug problem, and he's seeking help for that. I would ask the court to consider the policy purposes of the Tennessee Criminal Sentencing Reform Act of 1989. Among them is that the defendant should be punished by the imposition of a sentence that is justly deserved in relation to the seriousness of the offense. We ask the court to weigh the mitigating factors in light of that. It is also the policy goal of the Tennessee Criminal Sentencing Reform Act, its purpose, that effective rehabilitation be encouraged, where a defendant may, where reasonably feasible, undergo alternative sentencing and correctional programs that elicit the voluntary cooperation of that defendant. The court's encouraged to consider those options and promote their use when possible, when reasonably feasible. In this case, the defendant has been accepted to the recovery court of this judicial district. We heard testimony today that the defendant was accepted and that he is regarded as a good candidate for recovery court. So based on the purpose of the Tennessee Criminal Sentencing Act at 4035 1023C, this would be an alternative sentencing and correctional program that is based on the voluntary cooperation of the defendant. It requires his voluntary cooperation unambiguously, unequivocally, and it would promote his effective rehabilitation. And we believe it's reasonable. I would show the court that it is reasonably feasible here due to him being accepted and due to the effectiveness of the recovery court program. Central to this is the system, the regime of sanctions that's available in the recovery court process. This is not something that the defendant has ever been subjected to. This will be a new setting for him, new requirements, new conditions, new restrictions. And if he fails to comply with that, there is a wide range of sanctions that can be tailored to the problem to address it, should he fail to do what he's supposed to do in the recovery court program. I submit to the court that that is a serious commitment on the part of the defendant, and that him being subject to such sanctions through the recovery court reflects the seriousness of this offense and what the victims experienced. And so we ask the court to consider that as the proper choice for the defendant. Another thing that the court has to decide is the range of sentence on not the aggravated burglary, but the vehicle burglary and the attempted aggravated burglary. On those, Your Honor, I believe that there is a range of punishment that the court will consider. It may be less significant given that 10 years will be the sentence on the aggravated burglary, which is a C felony. And at range 3, the bottom of the range is 10 years. And that is the agreed upon cap on the aggregate sentence here. It would be 10 years at 100% on that. Nevertheless, Your Honor, because that is a ruling that the court does have to make, we would ask that the court give the defendant the bottom of the range in both of those. One of the advantages of sending the defendant to the recovery court program will be that it will address one of the issues identified in the risk assessment completed as part of the pre-sentence report. The defendant had a high rating of risk, or a moderate rating of risk, in the category of, I believe it was residential and perhaps relations. I'm not sure exactly what the language was used there. Friends, associates, and residential, 62% risk. That was his highest area of need, deemed moderate in the risk assessment. Recovery court would address that because his living situation will be controlled, and who he can associate with is controlled, and he'll be closely monitored. That may be something that speaks to, addresses Mr. McElhaney's identified need there, and therefore it makes it a better candidate, better option for him. So, in summary, Your Honor, there's a state legislative purpose or policy with respect to sentencing for there to be rehabilitation when reasonably feasible. The goal of punishment and deterrence is also met with recovery court, because sanctions for the defendant's conduct in that program are available and will be used. Recovery court has identified the defendant as a candidate for the program that they believe can be helped through the program. The consequence of the defendant's failure to abide by that program and complete it is serving his sentence. The sentence report that we heard testimony about corroborates that the defendant has a known drug issue that may be treated. Due to all of this, sentencing the defendant such that he has to attend recovery court and complete that supports more goals of sentencing than simply sending him to prison. So we ask that the court order the defendant to undergo recovery court and complete that. Thank you, Your Honor.
General Wojciechowski, you have anything else? Mr. Talbot has pointed out the provisions of the sentencing law. This court is required to adhere to the sentencing guidelines that our state legislature has promoted and adopted through statute. I can't just do what I want in a case per se. I have to abide by those regulations. And those are the purposes of the chapter that Mr. Talbot referred to are set out in 4035-102. And for that, I will go through some of those that were not mentioned by Mr. Talbot, who is a very able advocate for his client. First is that every defendant should be punished by the imposition of a sentence justly deserved in relation to the seriousness of the offense. 2, this chapter is to assure fair and consistent treatment of all defendants by eliminating unjustified disparity in sentencing and providing a fair sense of predictability of the criminal law and its sanctions. 3, punishment shall be imposed to prevent crime and promote respect for the law by A, providing an effective general deterrent to those likely to violate the criminal laws of this state. B, restraining defendants with a lengthy history of criminal conduct. C, encouraging effective rehabilitation of those defendants where reasonably feasible by promoting the use of alternative sentencing and correctional programs that elicit voluntary cooperation of defendants. And D, encouraging restitution to victims where appropriate. 4, sentencing should exclude all considerations respecting race, gender, creed, religion, national origin, and social status of the individual. And it goes on to talk about the encouragement of alternatives to incarceration under the appropriate case. This sentencing considerations are set forth in 4035-103. To implement the purposes of this chapter, the following principles apply. 1, sentences involving confinement should be based upon the following considerations. A, confinement is necessary to protect society by restraining a defendant who has a long history of criminal conduct. B, confinement is necessary to avoid depreciating the seriousness of the offense, or confinement is particularly suited to provide an effective deterrent to those likely to commit similar offenses. C, measures less restrictive than confinement have frequently or recently been applied unsuccessfully to the defendant. 2, the sentence imposed should be no greater than that deserved for the offense committed. 3, inequalities in sentences that are unrelated to the purposes of this chapter should be avoided. 4, the sentence imposed should be the least severe measure necessary to achieve the purposes for which the sentence is imposed. 5, the potential or lack of potential for rehabilitation or treatment of the defendant should be considered in determining the sentence alternative or the length of time to be imposed. The length of term of probation may reflect the length of treatment or rehabilitation program in which participation is condition of the sentence. 6, trial judges are encouraged to use alternatives to incarceration that include requirements of reparation, victim compensation, community service, or all of these. He goes on to talk about available community-based alternatives to confinement and the benefits that are imposing such alternatives may provide to the community should be considered when the offense is nonviolent and the defendant is a primary caregiver of a defendant child. So implementing those, both the purposes of the chapter and the sentencing consideration, the court finds that the sentence involved in this case would be taking into consideration that the defendant has a long history of criminal conduct. It's been pointed out that he has 20-plus years of criminal conduct, either 9 or 7, depending on which version you accept, felony convictions, multiple misdemeanor convictions. He has convictions for other convictions, prior convictions for theft, and a conviction for burglary in his past. Goes on, measures less restrictive than confinement have frequently or recently been applied unsuccessfully to the defendant, and the proof has been that the defendant was on probation out of Murray County at the time that he committed these offenses. So those are some court findings regarding the considerations and those factors that are set out. Then moving to determining the range, it was stipulated that he would be a range 3 offender or a persistent offender, as the law provides, which means that in the consideration of the Class C felony, his sentence, if it had been open to the court, would be 10 years up to 15 years. That would be the range for the Class C aggravated burglary. By agreement between the state and the defendant, he received the consideration of limiting or capping the sentence to 10 years so that the court cannot consider a sentence in excess of the 10 years that was ordered. The sentence range for the vehicular burglary, which is a Class E felony for a persistent offender, is 4 to 6 years. And for the attempted aggravated burglary, the sentence range is 8 to 12 years. And again, the agreement was to cap the sentence range at, or the sentence at 10 years. Court then moves to determine the sentence as to the enhancement factors that the state has submitted, and those enhancement factors are as follows. The defendant has a previous history of criminal convictions or criminal behavior in addition to those necessary to establish the appropriate range. Court finds that that factor does apply, that the proof, as I previously stated, is that he has a 20-year plus history of criminal conduct. He has multiple convictions, both felonies and misdemeanors, and has previously been on probation during that time. Number 3, the victim of the offense was particularly vulnerable because of age or physical or mental disability. I didn't get the impression Ms. Thaxton was very particularly so elderly that she was not disabled, but she is like me. She's not a young person, so I do find that that is a factor to it. And she lives alone, and being isolated in her home by herself, I think that is a factor that would be applicable in this case. Number 13 of the enhancement factors, that the time the felony was committed, one of the following classifications that is applicable to the defendant, he was released on probation. I find that to be, the proof has established he was on probation out of another county when he committed these offenses. And number 29, the offense involved the theft of a firearm from a motor vehicle, and the court does find that although he did not plead to the actual theft, that the proof here has clearly established that there was a theft of the firearm from the motor vehicle. That was part of the reason that the court asked the question of Mr. McElhaney, that how did the weapon get from the vehicle into the front porch of Ms. Thaxton, was to determine, number 1, his acceptance of responsibility, and number 2, his credibility as a witness. The court finds all of those factors to be applicable. So there are 4 factors, that enhancement factors that the court finds. The mitigating factors that the defendant has submitted are 1, that the defendant's criminal conduct neither caused nor threatened serious bodily injury. I'm happy that there was no serious bodily injury. Mr. McElhaney might want to consider the fact that in my growing up, if somebody had shown up on my father's doorstep in the middle of the night banging on the door, they might not be alive the next day to have to deal with anything. So luckily, there was no serious bodily injury or harm. The same thing with the other cases that were involved in this situation. I don't know that Mr. Zajac would have done anything like that, but I think there is, it is applicable to me that he's lucky that there was not a more serious result of this. But Ms. Thaxton deserves to live in her home without fear. Mr. Zajac and his family, they deserve to live in their home and have a sense of security, and they've been robbed of that by the actions of the defendant in this case. And while it might not rise to the level of serious bodily injury, it is a consideration that this court finds to be appropriate in determining the sentence in this case. Number 2, that the defense argues is number 7, rather. The defendant was motivated by a desire to provide necessities for the defendant's family or the defendant's self. I have listened to Mr. McElhaney and listened to the proof that the state put on from these witnesses about his behavior around their home is inconsistent with his version that he was simply looking for gasoline, or that he was, just wanting to cool off with a hose or whatever. He may have been on drugs, but my opinion is that you don't go looking for gasoline if you're committing a burglary of a vehicle. That's not the purpose of it. And so for that reason, this court does not find that there is any indication substantiating the fact that he was acting on behalf of himself and seeking the necessities of gasoline. I think that factor is also more applicable in a situation where a person commits a theft because their family is hungry or starving or something, and they've been motivated to provide necessities for themselves or their families. That's the court's interpretation of the purpose of that. I do not find that to be applicable in this case. Number 11, the defendant argues that the defendant, although guilty of the crime, committed the offense under such unusual circumstances. It is unlikely that a sustained intent to violate the law motivated the criminal conduct. This court is of the opinion that this defendant's prior criminal record of burglary and theft do not make this an unusual circumstance that he's unlikely to have committed another crime. I think it is consistent with his prior pattern of behavior and criminal conduct. In addition to that, this is not one isolated knocking on a door to see if anyone's home or whatever he was doing, but rather is a pattern of the neighborhood of him going from house to house and trying to see if there was anyone home that he could, for whatever purpose. So it's not a situation where I think it's unlikely it was sustained intent to violate the law that motivated the criminal conduct. So I don't find that those things are applicable as well. That factor is applicable as well. And number 13, the basically catch-all. The court is well aware that, and I agree, I think Mr. McElhaney has a drug problem. And as a result of that, I think he is clearly has been in for many years suffering from a drug addiction, and for many years has been in need of treatment. The problem with that is that he has been given opportunity after opportunity, including the Hope Center, and has not taken advantage of any of those opportunities. It seems to me that despite having been available treatment options for him in the past, it's like he said himself, he just wasn't ready for it. And I have great respect for the Dixon County, or the 23rd Judicial Drug Court. I think they do a great work, and I think Mr. Barnhill is a very compassionate individual. His job is to try to see the good in people and to try to help them redeem themselves. My job is to not only try to judge people as far as whether or not they are credible, but also whether or not they are willing to and undergo a treatment that would help them, but also to balance that with the respect that I have to have for the protection of the society as a whole. So while I have great belief in the drug court program, the fact that this gentleman has been on probation over and over and over again is an indication to me that recalls the old saying that the definition of insanity is repeating the same thing over and over and over again and expecting a different result. I hope that Mr. McElhaney is serious about wanting to have treatment for his addiction, but this court is of the opinion that rendering him into the drug court program is not in the best interest of society and does not comply with what I believe the requirement of the law is. So therefore, as to count 1 of the aggravated burglary charge in docket number 134, he is sentenced to serve the 10 years in the Tennessee Department of Corrections. Count 1 of the 135, he is sentenced to 6 years for vehicular burglary and is ordered to serve that sentence, obviously contemporaneously with the 10-year sentence that I've previously indicated. Count 4, he is on the attempted burglary, he is sentenced to 10 years on the attempted burglary, which is a Class D felony, and court has ordered that be run. I mean, the agreement is that it's capped at 10 years for an aggregate sentence, so he is ordered to serve all of those as concurrently, and also concurrently with his Murray County. He'll get pre-sentence jail credits as set forth on the plea agreement until today, and that is the judgment of the court.
Your Honor, for his pre-sentence jail credits, that would be amended to reflect his time through today's hearing.
Yes,
I would think.
he'll
Your
get
Honor.
pre-sentence jail credits through today.
Yes, sir. Thank you.
All right.